YTV Justice, VTR 1738, Part 1, Take 1.
I'm sorry. It was my fault entirely.
What happened?
Well, it was my fault entirely. I was waiting behind him to come out on the main road and my foot slipped off the clutch.
Have either of you two gentlemen been drinking?
I'm a total abstainer.
How about you, sir?
Do you know who I am?
No, sir.
I'm Mr. Justice Bebbington. I'm a High Court judge.
I'm sorry, my lord. I didn't recognize you.
That's quite all right.
You four men have been convicted of blackmail, robbery, and murder. During this trial, we have heard such phrases as protection, racket, and gang warfare. These are totally inadequate to describe your dreadful activities. A judge is the instrument chosen by society for two purposes. Firstly, to ensure a fair trial. Every point has been put in your favor, and yet the jury has reached unanimous verdicts of guilty. My second function is to decide punishment, to say where a line must be drawn between your rehabilitation and protection of the public. In this case, I have no hesitation in saying the safety of ordinary people is paramount. The sentence I impose is one of life imprisonment, and I recommend that each of you serves not less than 25 years.
Well done, Harriet. You deserve to win. He's a hard man.
On this case, he was fair and absolutely impartial. And with villains like that, I thank God for a hard judge.
Harriet, you know how important this is to me.
Miss Peterson, tomorrow is the last day.
Preston is the managing director of one of the biggest insurance companies. If I get taken on as consultant for their accident cases, it'll make all the difference to my practice.
I'm sorry, Dr. Moody, but I really must insist. If Miss Peterson is to stand any chance of becoming a QC, she must at least fill in the application form.
We're going to be late. I'm not standing this man up. Now, what the hell's she got to do?
She needs the written backing of 9 barristers. OK, she's got them. And 2 judges. Now, she's only got 1. You said you were going to tackle Mr. Justice Quentin for the other.
How was I to know that gangland prosecution would last 5 weeks?
Well, either that application goes in tomorrow, Or you can kiss goodbye to becoming a QC for another year, yes.
Tomorrow's the last day. What is the panic? You can see Quentin in the morning and Bill can take it round by hand.
Hang on a moment, please, would you? Mr. Justice Bevington's clerk. The judge wants to see you.
Bevington, you'll back your application.
You must be joking.
Yeah, now.
What?
He wants to see you now.
God.
No, I must go with Dr. Moody. Tell Bevington's clerk I'll see the judge in the morning, any time, anywhere, and then find out where Quentin is.
And make another appointment.
Just find out where he is. I'll get to him somehow.
You're in the divisional court at 12 on the Draper appeal, and you've got...
2 days to do 3 months' paperwork. You don't have to remind me.
Hello?
You simply can't go on working at this pressure.
That's why Bill wants me to take silk. Good night, Rosie.
Good night, Miss
It'll get rid of most of the written work, and then I'll only be working on the more important cases.
About time.
The snag is, it's easy to go bankrupt waiting for people to realize how important you've become.
More porridge, Sir Geoffrey?
No, thank you. Miss Peterson.
Thank you.
I don't think it's right to dispense justice on an empty stomach. I'm sufficiently bad-tempered without adding gastric insult to the judicial process.
You have a beautiful home, and judging by the smell, an extremely good cook.
Thank you. One of the advantages of the bachelor state. I can afford to indulge my somewhat fastidious tastes, and I don't have to compromise with a wife. And I can be honest about the cooking.
Delicious.
No, you've appeared before me on a number of occasions. I admire your work.
Thank you, Judge.
I haven't changed my mind about the law being no place for a woman, but as long as they're permitted to practice, I see no reason why I shouldn't take advantage of one of them. Well, look, I've got a rather difficult subject to broach, and I don't know where to begin. Society seems to expect its judges to be perfect.
Beyond reproach, certainly.
Well, I have been accused of a crime. That it's Road Traffic Act and not homicide doesn't alter the fact that it's a criminal offence.
People don't think of motorists as criminals.
On the bench, I've always taken the view that the motor car's potentially more lethal than the jemmy.
What's your crime, Judge?
Breathalyzer, driving with an excess of alcohol in the blood.
You've been charged?
It was a slight accident, not my fault, but that makes no difference on this charge.
Is there a date for the hearing?
3 weeks' time. I want to know if you will represent me.
Are you sure you want me?
Well, I realise this may come as a bit of a shock to you. I know we're not exactly friends, and I find relationships with women difficult. If a judge is charged with an offence, it causes embarrassment all round, official and personal. A conviction must lead to consideration of resignation, if not dismissal.
It takes an address to Parliament passed by a majority in both houses to sack a judge. The last time was 250 years ago.
I wouldn't put it past the present Lord Chancellor to try. The judge is acquitted, of course. There's no question of either resignation or dismissal.
Acquitted? Breathalyzer's usually cut and dried. You're either over the legal limit or you're not.
Nonetheless, I would like the evidence against me scrutinised by a good lawyer, and you satisfy that description. Should I be found guilty, I would like the circumstances explained sympathetically and tactfully to minimise embarrassment all round. Now, on that score, I regard you as without peer. Will you please defend me?
Of course, Judge.
Thank you very much, Miss Peterson.
Mr. Martin, Mr. Geoffrey.
Hey, good morning, Edward. And I think you know my personal solicitor, Edward Martin.
Hello, Mr. Martin.
Miss Peterson has just agreed to defend me, so you'll be delivering your brief to her in due course.
Very well.
Coffee, Edward.
Kind of you, Geoffrey, but I don't know that I should. My ulcer's been playing up.
Oh, how about tea?
That'd be better.
You please. Now, I should like to go through the preliminaries with you now, Miss Peterson.
Certainly, Judge.
Now, one thing we must get straight from the beginning. You must forget I'm a judge, or even a lawyer.
If you promise not to chuck your weight about, I'll go along with that. How about you, Miss Peterson?
I do say that a lawyer who acts for himself has a fool for a client.
And a knave for a lawyer.
I wasn't going to complete the quotation.
So you will forget I'm a judge?
It's impossible for me or Mr. Martin to forget who and what you are. But if you're asking me to play it by the book, to treat you as I would any ordinary client, I wouldn't take the case on any other terms.
Right. Good. Now, where shall we begin?
With your blood. Or did you give a urine specimen?
Blood, I believe that's supposed to give you the best chance.
Yes?
The defendant's under no obligation to help the prosecution prove its case.
The legal limit, Judge, is 80 milligrams of alcohol per 100 milliliters of blood. What was yours?
148.
My private analyst report said 146.
That's very nearly double the legal limit.
Well, I think it helps to point that out.
Where did this accident happen?
A village called Sarum in Berkshire.
Well, that means a bench of lay magistrates.
I imagine so.
The usual procedure, playing it by the book, is a plea of guilty before the magistrates, and in your case, a carefully prepared plea in mitigation, which will be followed by a fine and compulsory disqualification for 12 months.
Just so.
First, I want the facts, all of them. Then I will give you my advice.
Well, now, it was on a Wednesday.
Not now, I'm afraid, Judge. I have to see Mr. Justice Quentin the other side of London in half an hour, and I'm in the divisional court at noon.
Oh.
I'd like Mr. Martin to take a statement from you and send it down to me with a copy of the charge sheet and any other documents. I will consider them in the privacy of chambers. Then my clerk will arrange another conference.
Well, I suppose that is what I've asked for.
Thank you for my breakfast, Judge. Mr. Martin?
Speak, sir.
I'll see you both shortly.
I don't know why she's defending nasty old Bebington anyway.
Miss Peterson, if she gets here in the next 2 minutes, we'll be making an application to take silk. Judges have a big say in who gets to be Queen's Counsel. So now is not the time to be telling judges to get stuffed when what they want is defending.
I only asked.
Yeah, you ought to keep quiet about this, even in chambers. It's confidential.
I know.
Where the hell is this?
Well, when she phoned in to say Quinton couldn't see
Mr. Justice Quentin, to you, Rosie. She's not here in the next 10 minutes. She's had it. Miss Peterson, where have you been?
Chasing Quentin.
There's a list of phone calls as long as Oxford Street.
I finally caught up with him 20 minutes ago at his club. Women not admitted.
You've only 10 minutes before time runs out on your application
finally
for
signed
silk.
it on the doorstep, and so have I. Now, who's been after me? Martin. I forgot to tell you...
Not now, Miss Peterson. I'm taking this personally to the Lord Chancellor's office.
But you have to make room for the magistrate's hearing in the diary.
I'm going to find this a bit embarrassing, but... Well, I expect we better get on with it. My lord...
If I may interrupt you, sir.
But of course, my lord.
It is sufficient to address me by my given names and surname.
Oh, certainly, my lord. Geoffrey Harcourt Bebington, you are charged with driving a motor vehicle with an excess of alcohol in the blood, contrary to Section 6 of the Road Traffic Act 1972. Now, that is a charge in which you are entitled, if you so wish, to be tried by a judge and jury. I must now formally ask you whether you consent to be tried summarily by this court, or if you wish to be tried by a judge and jury.
My client elects to be tried by jury. And his plea to the charge will be not guilty. Would you like to wait in the conference room? I'm sure no one would mind.
No, I'll be all right.
Make way for the judge! Make way for the judge!
I'm going to robe.
Oh, yes, all persons having anything to do before my Lord the Queen Justice is drawn in and give your attendance. God save the Queen.
Hello, Geoffrey. How are you feeling this morning?
You the one brought the charge against the judge?
Yes?
Ah. I'm from the Herald. Can I have your full name?
Mitchell. Paul Mitchell.
Front page stuff, this. Care to make a comment about judges and the drink laws?
You must be joking.
You'll find out all about it inside.
You prosecuting the judge, sir?
I am.
Like to get the names right, at least.
Basil Stewart, S03E09.
QC? Ah. Well, who's going to win?
You'll find out inside.
Thank you. Sir?
Word with you, officer.
Sir.
You're in charge of this case?
Yes, sir.
Well, Judge Bebington's got a pretty fierce reputation, but no need to be nervous. Just treat it like any other case.
Oh, I'm not nervous, sir. I don't know why everybody calls him a hard judge. Perfectly all right with me. Strange him pleading not guilty, though, sir.
What do you mean?
Well, you can't plead not guilty when your blood alcohol's 148.
You know as well as I do there are technical defences to the breathalyzer.
Well, this one's cut and dried, sir. I feel sorry for his counsel.
I don't feel sorry for Miss Peterson. She's good. She's damn good. And remember, no one pleads not guilty to the breathalyzer without very good grounds.
Who's the judge?
Quentin. Probably the best High Court judge we've got.
We're next on. Bebington's very cool.
Oh, that can't be bad.
There's something I don't like about this case. It's too neat.
At times you worry too much, Miss Peterson. You've a good chance to shine. Take it.
Perhaps you're right.
Oh, I've had the acknowledgement from the Lord Chancellor's office of your application for silk.
We just have to keep our fingers crossed, won't we?
Dr. Moody's here. He'd like a word.
Thanks, Bill. Harriet?
Hello, Ian. What is it?
Marvellous news. I've landed that insurance company job.
Oh, good.
Thanks to your persuasive advocacy.
Nonsense. You've got it on merit.
I'm already working on the first case. An accident victim, a girl of 16. Pretty academically brilliant. It could be a very big claim.
Why, especially?
Extensive head injury.
Peterson.
Ian, I must go. I'll see you at 7.
Well, I have to go to the hospital, see the girl. I might be late.
Then I'll expect you when I see you.
Right.
Bye.
Bye.
Congratulations. I see you've been made a recorder.
Thank you. This is my first case since the announcement, so I've got to win this one.
Not a chance.
Oh, can't lose.
Court will be upstanding.
Crown against Bebington.
I appear for the prosecution in this case, my lord. The defendant is represented by my learned friend, Miss Peterson.
Just a moment, Mr. Stewart. Miss Peterson, it is the practice in my court, after the jury has been sworn in, for the defendants in motoring cases to sit behind their counsel instead of in the dock, if they so wish.
I'm much obliged, my lord.
The reason for a dock is to ensure that defendants remain in custody during trial. In motoring cases, there is usually no risk of an accused person trying to escape that custody. That is the only reason. In this case, or any other.
Geoffrey Harcourt Bebington, there is one count in the indictment against you, driving with an undue proportion of alcohol in the blood, contrary to Section 6 of the Road Traffic Act 1972.
Rosie, you are my posy. You are my heart's bouquet. Oh, no, Rosie. There you go, William. Chalk up another victory.
Mr. Elliot.
I finally persuaded the judge to commit that bastard to Brixton until he stops harassing his ex-wife.
Well, the solicitor will be pleased, aren't Ben?
Pleased, he even took me out to lunch. Hey, where's Harriet? I've got a rather tricky custody I'd like her opinion on.
Crown Court, defending a judge.
Oh, accolade time. Who's the judge?
Bebington.
That crafty old bath bum. What's he been up to?
Breathalyzer.
a plea of guilty?
No, it's a fine.
What's the defence?
Why are you so interested, Mr. Elliot? I'm supposed to keep quiet about this.
Well, what's so secret, William? If it's in court today, it'll be in the papers tomorrow. Come on, stop being so furtive. What's the defence?
Well, it's a technicality, something about the arrest.
I don't believe it. I don't believe it.
What?
It's just possible that Bebington is using Harriet to set up a crooked defence. Get on the phone.
But I can't. The case began this morning.
In that case, the mountain must go to Miss Mullins.
You've got a conference at 3:30.
Yes, all right, I'll be there. Which court is she in?
Is this really necessary, Mr. Elliot?
Necessary. William, if I am right, Harriet is in trouble, real trouble.
After he identified himself, I put the question again.
What was his reply?
Yes, I had a drink at lunchtime.
Did you then invite him to blow into the breathalyzer?
Yes, and the crystals turned green. I told him this meant the result of the test was positive, and I must arrest him and take him to the station.
You went to the station?
Yes, he there took another breathalyzer test, which also proved positive. I told him this meant that he was obliged to give a blood or urine sample. He chose blood, so I called the police surgeon. He arrived at 5:43 p.m. and took a sample of the defendant's blood. This was then divided into 2 containers, and he was offered his choice of the 2 to take away.
The analyst has produced a bottle which contained an alcohol level of 148. May the witness see Exhibit 2? Are those your initials?
Yes, my lord.
Did you date and mark the bottle for identification?
I did.
One final point. What was your reason for applying the breathalyzer?
There was an accident at a T-junction.
Serious?
No discernible damage to either car.
Is it right that the other driver admitted responsibility for the accident?
Yes.
Then why the breathalyzer?
Whenever there's an accident, I can require the driver to take a breath test.
Indeed, that is the law, but was there any special reason in this case?
I noticed the smell of alcohol on the defendant's breath.
Thank you, officer.
You have given your evidence with commendable clarity, but I'm bound to suggest that the facts did not occur as you have described them.
I did, miss.
How old are you?
21.
How long have you been in the police force?
2 years.
You are comparatively inexperienced.
I think I know my job.
My client identified himself to you at the scene of the accident as a High Court judge.
Yes.
Didn't that make you nervous?
Well, it's true, I've only done 2 breathalyzers before. Neither of them a High Court judge.
Yes, it was an unusual situation. Embarrassing. You felt diffident, not too sure of your ground. I would like to describe to you the way the incident occurred according to my instructions. You tell me whether that description is right or wrong. The judge saw that you were young and inexperienced. He was a High Court judge. It was important there should be no fuss, no crowd collecting. Did he not say to you, the breathalyzer bag, let's have it?
Yes.
He took it, blew into it, and said, the crystals have turned green. That means the test is positive.
Yes.
That means I can't drive my car in case it turns out I'm over the limit. So you move it out of the way of the traffic.
I would have done that anyway.
But he suggested it.
There's no harm in that.
When you had moved his car, did he not say to you, what you have to do next is take me to the police station in your car? Where do you want me to sit, in the back or beside you?
Yes.
And you replied, whichever you like.
Well, I don't remember my exact words.
When you arrived at the police station, he said, now I have to take another test. Get me another bag. You found one, he blew into it, and once again the crystals turned green.
Oh, I had another kid on me.
That means I have to take a urine or blood test. I choose a blood test. That means the police surgeon. You ring him up, tell him what it's about, and to get down here as soon as possible.
You're making it sound as if I didn't know what to do.
I'm not criticizing you, officer, but a High Court judge is a very important person. This particular one has a strong personality. When he decides to tell someone the correct legal procedure, he's not likely to be contradicted.
That's true.
The police surgeon arrived, took a blood sample, divided it into 2 containers, and my client said, now you have to give me the choice of those 2 containers, so I can have my own analysis done. He chose one and said, you mustn't let me leave the station until I blow into a bag and it doesn't turn green. For God's sake.
Miss Peterson, do you have problems?
No, my lord.
Then may we proceed?
That was how it happened?
Yes, well, it's sort of like that.
Just as I have described it.
More or less.
More or less won't do, officer. It was exactly like that, wasn't it?
Look, miss, I went straight down to the police canteen after it was all over, and I wrote up my notebook exactly...
By yourself?
No.
With the help of a friend, perhaps?
Just so I didn't miss anything out.
A friend with rather more experience than you have.
I didn't make anything up, miss. I've given my evidence according to my notebook, and that is the truth. Can't see there's any difference between my evidence and what you said.
I never mentioned the word arrest.
Well, I did.
This afternoon, yes. But at the scene of the incident? You have agreed with me it was the defendant's suggestion you went to the police station together.
I must have arrested him, otherwise I would have written in my notebook.
Not even with a friend making sure you left nothing out? What words did you use? I arrest you? Did you really say that to a judge?
I stick to my original evidence. I said I must arrest you.
No, officer, that's not good enough. The court has to know whether, in fact, there was an arrest. In other words, how you arrested him. Did you take him by the arm?
I didn't touch him.
Did you speak sharply to him? Did you make it plain to the defendant he had no alternative but to accompany you to the police station?
It wasn't necessary. He was going to come anyway.
Miss Peterson, I see your point.
But may we clarify that for the jury?
My lord, it is one of the essential elements of this charge that the defendant should be arrested. That means there must be at least some compulsion in taking him to the police station. Without that compulsion, the prosecution's case is defective. Fatally so.
My lord, I can't allow that to go unchallenged.
I submit... opportunity, Mr. Stewart. Yes, Miss Peterson.
Finally, officer, the defendant was in full command of his faculties.
His breath smelt of alcohol, and that was the only sign there was.
Thank you, officer.
I think we might adjourn there until tomorrow, 10:30.
All stand.
Harriet, I take a serious view of your interruption of Miss Peterson's cross-examination. Worst possible moment, we will have wrecked the defence.
I hope so.
James!
I shall report your conduct.
You set Harriet up.
No idea what you're talking about.
Do you deny that on the morning of the day you were breathalyzed, I appeared before you to defend a case very similar to this?
I can't remember every case I deal with.
In which I made the submission there had been no valid arrest?
I have no idea of what you're talking about and no intention of finding out. If you have any sense, Miss Peterson, you won't listen to him either. Edward, you were going to run me home.
What's all that about?
What the hell are you up to?
You're being used, Harriet, and used dishonestly.
How?
It was 5 in the afternoon when Bevington got done by that young copper.
Yes?
Earlier the same day, and I've checked the dates, I defended a retired superintendent of police on a breathalyzer before Mr. Justice Bevington. Now, my super wasn't 148. His alcohol level was 230, practically paralysis for any normal human being, but he had a head like granite. Well, first, he tried to bulldoze his way out of trouble by pulling rank on the young copper to get him to drop it. Well, when that didn't work, he went on the other tack. All right, let's get on with it. Give me the bag. I'll blow into it. Puff, puff. Oh, dear, the bloody thing's turned green. Right. Leave my car where it is. We'll go down to the station in yours. Now, he had so much booze inside him that he was getting ugly. And naturally, the young copper didn't want any aggravation, so he let the super do it his way. The next day, my client didn't remember anything except that he wanted to fight. Well, I thought we didn't have a chance. And then all that lot started coming out in cross-examination. It was hilarious. The super tried to stop me going on with it, said it was making him look a fool, wanted to change his plea to guilty. But I got him off on the identical technicality that you are using today. And Mr. Justice Bevington congratulated me, called me a genius for spotting a novel and unusual defense, 1,000,000 to 1 shot.
Go on.
Yeah, well, later the same day, when Bevington got done, he saw the perfect opportunity to set up exactly the same defense. Now, that is not only dishonest, that's practically conspiracy.
Are you saying a High Court judge would do that deliberately to a young and inexperienced constable?
There is no other possible explanation. In my case, it was accidental. In Bevington's, it was deliberate. It must have been. First, he set up the cop, and now he's done the same to you.
My first instinct was to refuse this case. At the very beginning,
If you go on with this, knowing what you know now, you'll be in worse trouble than he is.
Thanks very much. Why the hell tell me?
Could you stand by and watch me put up a crooked defense?
There's nothing I can do.
Harriet, there will be publicity. High Court judge fights drunken driving charge. I wasn't the only one in court on that superintendent's case. There will be others who will make the same connection. The facts are bound to come out. And when they do, there will be such a stink that you will blow your chance of silk. You might even face disciplinary charges.
Is it true?
That Elliot made a similar submission to me, yes.
Then is your defense honest, or did you deliberately mislead the constable?
That has nothing to do with you.
I can't put forward a spurious defense, you know that.
Spurious is a word without meaning in this context. Either I'm guilty or I'm not. Motives are no part of English law.
I have a duty, Judge. I have to know.
Why do you have to know?
To get at the truth.
Why is that so important suddenly?
I know all the cynical replies. I give them myself, but we are defending a judge.
Suppose for one moment I say, yes, it was premeditated. I saw a chance of misleading a young policeman as I'd seen another constable misled. I charted a careful course to wreck the police case on the legal rocks. Now, what will you do?
Advise you to change your plea to guilty.
Why?
It's the only honest thing to do.
Honest by whose standards?
Surely everyone's.
You're confusing law with morality.
Then you admit there is a moral issue.
Not at all. I'm saying there's no moral issue, only a point of law. Can our client be proved guilty or not? Now, I know, and you know, that he can't.
Was it premeditated?
None of your business.
Will you give me your assurance I am putting forward an honest defense?
Oh, why the hell should I? My conscience is my business.
Because if you don't give me that assurance, I shall have to consider whether or not I carry on with this case.
I'm a lawyer and I see no professional problem.
Well, the Lord Chancellor is at present considering your application for silk.
What has that to do with it?
You're so confused about your responsibilities, you're putting vague suspicions about motives before your duty to your client. Most lawyers would say you weren't fit to be a barrister, let alone one of Her Majesty's counsel. Miss Peterson, I have to know what you're going to do.
My duty, Judge.
You have your instructions, Miss Peterson. I don't see how you can be criticised for carrying them out. They're proper instructions. The point of law is technically a good one. Get him off, Miss Peterson. That's what you're being paid for. And you've got the ability to do that. And you've got the guts to deal with the consequences, Lord Chancellor or no Lord Chancellor.
The planning bar is short on silks, and the work on that side seems to be on the increase.
I don't like the chap, so I can't stop him on that score. Next.
Harriet Peterson, Lord Chancellor. You turned her down last time because of some unsavoury publicity over a doctor.
What was that about?
Dr. Moody was up before the General Medical Council on adultery charges. Now, she spoke up for him, admitted they were living together. You decided at the time that although standards had become more liberal, perhaps the dust should be allowed to settle.
What happened to the doctor?
Oh, he got off.
And what's the position now?
Well, we did some checking. They're still together.
Living together?
Separate establishments. You asked me to remind you that she's defending Bebington on this driving thing.
Isn't that over yet?
Well, the result's expected sometime today.
Quentin's the judge, isn't he?
Yes.
I've asked him for a report on the case.
From the Bebington angle?
Won't do any harm to wait a day to see if he says anything about Peterson.
No, Quentin signed her application, so it's hardly likely.
Maybe. Next.
You did write her a letter last time, practically promising it to her this year.
We'll wait. Next.
Braithwaite. The Prime Minister.
Oh, not again.
Yes, Miss Peterson?
It is my submission, my lord, that the case should go no further. The requirement of the Act, Section 8, subsection 4, makes it clear that once the initial breath test has proved positive, the defendant must be arrested. The police officer has admitted there was no arrest. Therefore, everything that followed was, in law, of no effect.
You're making your submission to me as a matter of law?
Yes, my lord. I say you should direct the jury to acquit because there is a fatal defect in the prosecution's case.
There is a line of cases which says that arrest is a question of fact to be decided by the jury.
It is my submission that the testimony of the police officer shows there is no evidence on which the jury could find there had been an arrest.
I can't accept that, my lord. The officer said the words, I told him the results of the test were positive and I must arrest him.
I have a note here that when asked if he told the defendant that he must accompany him to the station, the constable said it wasn't necessary, he was going to come anyway. That is quite inconsistent with arrest or compulsion.
Just so, my lord. But in chief, he did say he made an arrest. He has also maintained under some pressure that he made an arrest. At least this is an issue for the jury.
I'm not with you, Mr. Stewart. With such unequivocal words from the constable, it would be unsafe to leave it to the jury.
As your lordship pleases.
Members of the jury, the judge has a number of functions to perform during a trial. One of them is to decide points of law and to direct you as to what the law is. Technicalities in breathalyzer cases are a happy hunting ground for lawyers, and judges are frequently called upon to decide these matters. The absence of any reliable evidence of arrest is a fatal defect on a breathalyzer charge. And I must therefore direct you, as a matter of law, to return to me now a verdict of not guilty.
Members of the jury, are you agreed on your verdict?
We are.
Do you find the defendant, Geoffrey Harcourt Bebbington, guilty or not guilty?
Not guilty.
And is that the verdict of you all?
Yes, my lord.
You're asking the cost, Miss Peterson?
I leave that to your lordship's discretion.
This case has been decided on a technicality. There is no merit whatsoever in the defense. There will be no order for costs. Miss Peterson, your defense raises a number of questions in my mind. I'd like to see you in my room.
All stand.
Congratulations, Harriet. Very nice point of law.
I must remind you the relationship of lawyer and client exists between us. You are bound by strict rules of professional secrecy.
In your own interest, Miss Peterson, I advise you to tell him nothing.
Campari soda, isn't it, Mr. Elliot? Campari soda and a scotch, please, love. Large. It's always crowded lunchtimes. You're lucky I'm known.
I'm sorry, do I know you?
Oh, well, let's say I've followed your career with interest.
Ah.
I'm what you might call a student of the law. I'd have made a good lawyer. I have an inquiring mind.
Yes, of course I know you. You're a reporter. You were in court yesterday.
It's no secret. My name's Scott. I'm on the Herald.
Well, thank you, Mr. Scott. I've always believed in good relations with the press.
Well, here's to the law. You know, it's funny, but some barristers don't believe in talking to reporters.
Well, that's true.
Yes. What were you doing in court on the Bebbington case?
Oh, why shouldn't I be?
I mean, isn't there some professional rule or other which says counsel must not be interrupted during cross-examination? Well, Bebbington seemed to think so.
Really?
Look, all I want is the truth about Bebbington. And you can trust me, I never reveal my sources. In return, any time you want publicity, nothing but headlines.
Thanks for the drink. Excuse me. Sorry. Thank you.
I already have a story. Now, what was the elegant James Elliot doing in court when Mr. Justice Gestapo was charged with drunk driving? Why was he so interested? Why interrupt proceedings? Or was he bored? Because he'd heard it all before. Well, I could name you 3 magazines who'd take that verbatim. You wouldn't come out of it too good. And neither would the esteemed Harriet Peterson. But it would flush out the facts.
Flush away. But do make quite sure that your facts are correct.
Excuse me. Thank you.
That 16-year-old girl, my first case for the insurance company, she died.
Oh.
Well, she's better off, really. She'd have been a vegetable if she'd lived. The solicitors tell me she'd have got massive damages, but now she's dead. My company will only have to pay out peanuts. I know you can't take it with you, but it does seem wrong. Yeah. The driver's for it. He was drunk. Twice the legal limit.
Oh, Miss Peterson, there's a lot of calls. The solicitors on Draper want the new pleadings in a hurry, and 3 new sets of papers came in today. You all right, Miss Peterson? What happened about Bebington?
I got off.
Well, well done.
And I was sent for by Quentin.
What did he want?
The background.
All of it?
No. But I told him everything. I was so bloody angry with Bebington for putting me in that position. How dare he? How dare he use me like that? Leading me along like trusting idiot that I was. And I knew from the very beginning there was something wrong.
What's Quentin going to do?
He's giving a full report to the Lord Chancellor.
Oh.
Yes. Quentin says the Chancellor will want to see me. And Bebington's threatened me with the Bar Council for breach of professional confidence. To hell with taking silk. I'll be lucky if I'm left with a career. I don't know what I'm going to do.
I've had case number 2 for the insurance company. It's a film star. She fell downstairs, and it's costing my company £10,000 a day until she's declared fit for work. They're making the film in France.
To hell with it. To hell with all of them. Let's go out.
Well, I can't. My company's having to shell out £10,000 a day until this film star is put back to work. And, well, I have to fly to Paris tonight.
Paris?
It's just for one night.
How old is this film star?
Late 20s, early 30s. Why?
I'll come with you. Bill?
Yes, Miss Peterson?
I'm taking tomorrow off.
Yes, Miss Peterson.
You mean it's all right?
Yes. I can cover you at the Bailey and cancel 2 conferences.
What are we waiting for?
Thank you, Bill.
These people are not here at my invitation. You insisted on being faced by your accusers, as you put it.
And Braithwaite there?
I shall make decisions as a result of this meeting. Permanent secretaries always take notes. Surely you're not questioning his discretion.
I've broken no law, no code of ethics, no professional etiquette. What I object to are the Star Chamber methods.
I asked you in for an informal chat. You turned it into something else. The problem is of your making, Bebington, and I do not propose to discuss it further. Is that an end of the matter so far as you are concerned, Elliot?
Not quite, sir. I saw the judge in the corridor after the case. He congratulated me. Thought my client should have gone inside on the merits of a 230 alcohol reading. Nice point, he said. Nicely taken.
What's the significance of that?
You ask for all the facts, Lord Chancellor. That's another one.
You want to ask him anything? That's all, Elliot. Peterson, have you anything to say?
Yes, I don't know why I'm here. I've been back over my conduct of the case, and I don't see where I can be faulted.
A judge has been charged with a criminal offense. He's been acquitted in circumstances which raise questions of judicial propriety, morality, code of ethics. You conducted that defense. You have also applied to become one of the Sovereign's personal counsel. The Queen makes that appointment on my recommendation. Do you say that I'm not entitled to inquire into your behavior?
You are entitled to make every inquiry to ensure that I am a suitable candidate. But I also have some rights. When I defend an ordinary client, he doesn't know the law. I know nothing of his occupation. He can lie to me, cheat me, mislead me. And if he succeeds in doing those things, I have only myself to blame for not having spotted a villain. But when I defend a judge, I expect a very different set of standards. You deliberately deceived me. You led me to believe I was putting forward a unique, accidental technicality, which only arose because you were trying to help a young policeman in a difficult situation, whereas in reality, you set a trap for an inexperienced man who would be overawed by your rank, and then you set me up to be the instrument whereby you would escape punishment. If those are the standards of QCs and judges. Have you finished with me, Lord Chancellor?
Miss Peterson, hear me, please. Until this minute, I believed that everything that went on in my head was a matter between me and my Maker, no one else's. You have interpreted my actions in a way I never intended. You've attributed to me motives I'd never formed. I knew the point of law was a good one. I was troubled as to whether I had the right to use it. I decided not to tell my legal advisors, to make them treat me as a layman, and see if the point occurred to them. You picked it out for yourself. Mr. Edward Martin, my able and respected solicitor, reminded me that technicalities are part of the law's protection of the citizen, and a judge is just as much a citizen as anyone else. He also told me that a man would be a fool to plead guilty to an offence he had not technically committed.
You created that technicality by deliberately misleading the constable, and you deliberately misled me.
How can you possibly tell that?
Oh, there's no other explanation. That very morning, you had sat in judgment on an almost identical case. And then afterwards, all the equivocation with me, I asked you if your defense was honest.
Didn't it occur to you that the only explanation was I simply couldn't answer your question? When that constable asked me, have you been drinking? The adrenaline pumps through the veins just as quickly when you're a judge. I was scared, not only for myself, for the office I hold. The one thing I wanted to get out of the public gaze as quickly as possible. You're asking me what went on in my head at the second I should have been arrested? At a time when the alcohol level in my blood was nearly twice the legal limit, and I don't know. I've thought about it for hours. I've reconstructed the scene 100 times. I still don't know. And the only possible reason I don't know was the whiskey I'd had that lunchtime. Of one thing I'm certain, I would never have done it deliberately. Would have been out of character. So I allowed myself the benefit of the doubt. And until you said your piece just now, I would never have admitted that to anyone.
We need to detain you no longer, Peterson.
Thank you, Miss Peterson.
Train now arriving on platform 10 is the 725 from Leeds and Wakefield. British Rail regret to announce a delay of 15 minutes in the departure of the 10:05 to Newcastle due to a signal failure at Grantham.
May I have a Times, please? Thank you.
A mad, extravagant fool. Only judges buy these. Barristers rent them by the hour, and then we only wear them on ceremonial occasions.
And on your formal introduction, when all the new silks go round the courts and bow to the High Court judges.
How many judges are there?
Oh, about 60.
What?
Do I have to bow to all of them?
No more than half.
There you are, you see, the wig's paid for itself already.
Oh, Ian, have you seen the announcement in the Times?
Yes, of course.
The second paragraph.
Mr. Justice Bebington has resigned as a High Court judge due to personal reasons. Was that necessary?
If he'd pleaded guilty, no.